And welcome to another edition of HOA Today. I'm Mark Foster on the HOA Leadership Network. Well, if you're a board leader that's managing a homeowners association here in Minnesota, or maybe you're just an HOA resident, chances are you probably have a lot of questions regarding the duties and responsibilities of not just the board, but homeowners too. As it turns out, both have significant rights and responsibilities according to not just governing documents of the HOA, but also Minnesota law. Here to discuss all of this is Ryan Fargo. Ryan is an attorney with SJJ Law, one of our great sponsors here in the Twin Cities. Ryan, so great to see you today.
Yeah, thank you, Mark. Thank you for having me.
You were one of our speakers at HOA Day, which is our annual event of the HOA Leadership Network. And it was great to see you on stage over at the Ames Center in Burnsville. We're looking at some of that footage right now. And I think that our members really appreciated your topic, which was what we're going to talk about today. So let's get right into it. Let's talk about duties and responsibilities. One of the things that you discussed at HOA Day was really, there are significant duties and responsibilities, not just for the board, but also for homeowners themselves. So can you explain the difference? You talk a little bit about duty and responsibility in the context of a homeowners association. What is that distinction?
Sure. So a duty is a legal obligation. So this is something that by law, you as a board member or as a homeowner must do. So this is prescribed by law. A responsibility is a little bit more nebulous, and we define it as an ethical obligation. So this is something where your attorney might say, you don't have to do it, but it's best practice. It's something that as a board member, as a homeowner, you should do.
Mhm.
So that's the distinction between those two. And when it comes to HOAs, there are a lot of duties and there are a lot of responsibilities facing both board members and homeowners alike.
Right, and we'll get into that a little bit more here. So let's talk first about some source of duties. So, you talked a lot about the duties that come from governing documents and also Minnesota law. Can you elaborate on how, these two sources really influence the operations of a homeowners association?
Sure. So it's a surprise to nobody who lives in an HOA that an HOA is governed both by law and its governing documents. Its governing documents being the contracts that establish the rights, powers, obligations, responsibilities of the HOA and of its members themselves. The two main governing documents that are going to be really pertinent to your life as a member of an HOA are the bylaws
Mhm.
and the declaration. The bylaws are the document that really control the structure of the HOA and how the HOA runs. So that's where it says how many board members there need to be in your particular HOA, or how often meetings need to be held, how those meetings need to be run. So it's kind of how the sausage gets made. That's the bylaws. The declaration is a little bit more interesting, and that's where its powers and duties and responsibilities come from. So that's where it's going to list what the association needs to maintain, what it can and cannot do, how it can how it can assess things. Then on top of all of that, we have Minnesota law. The main one for HOAs being called MKIWA for short. It's the Minnesota Common Interest Ownership Act. You can think of this as a big umbrella that covers the governing documents, and this will fill in ambiguities in the governing documents, sometimes modify the governing documents. If there is a conflict between, say, the Declaration and MKIWA, Minnesota law wins. So if the Senate or the Minnesota legislature decided, we think this is important enough to cover in Minnesota law, that will govern your HOA too.
Okay, so Kiowa law really is the last stop. And of course, we all know that HOA reform is probably coming back to the state capitol in February of 2026, and we'll keep our eye on that. That's probably a separate conversation. Let's talk about the use of the words shall and may. You know, from a legal perspective, you run into this all the time. Homeowners and our board members, particularly some of our network members, always ask us about this. What's the difference between shall and may when they're enforcing a governing document? You shall do this, you may do this. Is there a difference?
A huge difference. This is perhaps the most important distinction when it comes to actually making decisions for and running your HOA, especially if you are a board member. If something in the declaration says you may do something, so you may get this particular higher form of insurance, or you may maintain this particular part of your common elements or part of your HOA, it means it's optional. While it might be advisable, while your lawyer might say, you should do this, it's not strictly necessary. So that's may. Shall, on the other hand, is strictly necessary. That is a legal duty, a legal obligation that the board has to do.
Hmm.
So why this is incredibly relevant to boards is this is true. A shall is a requirement, even if it is something the board really does not want to do. So, for instance, if the governing documents, and all of them do, say the association shall collect dues, shall collect the monthly assessments, even if there's an individual who is in a really bad situation and makes a very good case for why, you know what, can you just give me a break for this particular month? While my heart goes out to them, the shall will win. And even if it's unpalatable, even if the board doesn't want to, they have a legal obligation to follow that requirement. So that's where the distinction comes in.
Yeah, so maybe everybody, all board leaders like me, I'm a board leader. We should insert the word thou before shall. It sounds a little more official that thou shalt get this
True,
done.
I agree with that.
Right. So let's talk about the management of money and the fiscal responsibility. Some of these boards are managing a lot of money, and it's not their money, it's the homeowner's money, and it's all part of managing a what is essentially a nonprofit corporation. Could you discuss, Ryan, the significance of a fiduciary duty for board members, and how does it impact the management of the association's budgets and reserves?
Yeah, it's a very good question, especially because I think everybody who's lived in an HOA, or especially if you're a board member, has heard that phrase, fiduciary duty, thrown around, but it's very rarely defined.
Hmm.
What a fiduciary duty is the requirement that boards who have the fiduciary duty make decisions in the best financial interest of the association, of the nonprofit corporation. This means that if there is a split between one course of action and another, and one makes better financial sense, that duty is going to point the board towards the decision which makes the most financial sense. This quite often applies to budgeting. So all associations need a budget. Let's say the association wants to put up a big billboard or to advertise for their HOA because it's fabulous and they want everybody to move in. So they just slip that into the budget. Well, me as an attorney, as an HOA attorney, I might say, you know, is that decision, is adding that expenditure into your budget actually in the best financial interest of the association? Probably not. So I don't think that making that decision would uphold your fiduciary duty. You sometimes see this too with reserves. So all associations or most associations have reserves for what are called capital improvements. So you save up money so that you can repair the roofs if you need to. Well, it's tempting to want to use those reserves for paying a bill or paying off something else for the association. Well, your fiduciary duty kicks in, and
Mhm.
again, as your attorney, I'd go, well, that's not really what it's for. That's maybe not in the best financial interest of the association.
Right. So as board leaders, we do have that fiscal responsibility. It's important that we're adhering to those practices and making good decisions when it comes to managing the money that really isn't ours. It's really the residents' money. So, you talked a little bit about reserves. You talked sort of intimated about maintenance. That brings us to the subject of contractors. Not every board leader in an HOA has had a lot of experience with contractors or contracts or the whole RFP process. Ryan, from your perspective, what are some best practices that associations could use when they're hiring contractors to implement not only maintenance projects, capital improvement, but also their reserve study maintenance plans?
Well, so I'll take that question in reverse. Uh, all associations, by law, are required to have something called a preventative maintenance plan, or a PMP for short. So we talked about legal duties or duties, they are legal obligation. This is one of them. MKIWA says all associations must have a PMP in place. This preventative maintenance plan governs how the association is going to do walkthroughs, do inspections, how they are going to handle maintenance work as it arises. So it's out in the open how the association is going to deal with those kind of things. Now, let's say you have a preventative maintenance plan. You do an inspection and you see, oh, shoot, the decks for these 4 units, which the association, per their governing documents, are required to maintain, they need to be repaired. Well, nobody's an expert in everything, and nobody is expecting the board to go out them themselves with a hammer and some nails and go fix it. So it actually becomes part of the board's duty to hire a contractor. Now, you asked about best practices for doing that. One of the best things to look for is simply do your due diligence and Google them. Look for reviews. Look for testimonials. You also want to make sure, and you can talk to the contractor themselves, that they are insured. You want to make sure that they are insured. You want to make sure that they have their licenses in place, that they're accredited. All of that work on the front end can save you a lot of headache on the back end, knowing that, in the knock on wood event something goes wrong, well, they have insurance. That is part of the board's legal duty to make sure that they're doing their due diligence on the front end.
Yes, and even if there is a property manager in the middle of all of that, where a property manager is hiring the contractors, boards should be asking those very same questions about insurance and about credibility, right?
Absolutely. And if the board has a question too, they really can't make a decision. Oftentimes, property managers will have had a prior experience with a particular contractor or a particular vendor, and they might have something to say about, oh, you know what, I've had a fabulous experience with them, or we worked with them before and not so great. So they're a great resource as well.
We're talking today with Ryan Fargo. He's an attorney from SJJ Law. We'll get into a discussion about board governance and the different types of meetings that board leaders need to hold in their HOAs. We'll do that after this very short break. If you're an HOA board member with a desire to stay on top of HOA issues, now's your chance to join the fastest growing education association in Minnesota, the HOA Leadership Network. Our mission is to support HOA leaders through education, collaboration, and research. There are 4 chapter locations in the metro area. Membership is free, and meetings are monthly. For the schedule near you and to join, visit HOALeadershipNetwork.com. Thanks again for joining us. I'm Mark Foster on the HOA Leadership Network. We're talking with Ryan Fargo of SJJ Law. And Ryan, let's talk a little bit about association meetings. There's a lot of meetings, really, when it comes right down to it. When you are a board leader, there are the regular monthly meetings that go on that's sort of running the day-to-day operations of the HOA. There's annual meetings, there's working meetings, there's probably other meetings I haven't thought of. It seems like there can be a lot of meetings, and I think there's confusion around that. Can you talk a little bit about the importance of each type and how it contributes to the overall governance of a homeowners association?
Sure. So you mentioned two of the main types of meetings already, which are annual meetings and then board meetings. So annual meetings are the big yearly meeting where the association, all of the association gets together and the board gets to share the budget for the next fiscal year, and homeowners get to vote on the next board members that they want to be on the board. So this is the big cumulative meeting at the end of one year and at the beginning of the fiscal year of the next. Uh, Board meetings themselves are, like you said, more about the day-to-day governance of the association. So we've talked a little bit about maintenance. If the decks need to be maintained, this is where the board might talk about the vendors that they're thinking about, or the fact that the decks need to be maintained in the first place. One of the things that I think is very important to mention here for boards specifically is that both of these meetings, by Minnesota law, so MKIWA, the Minnesota Common Interest Ownership Act, have to be open. This means that board members have to, or sorry, pardon, homeowners need to be able to attend these meetings. And at annual meetings, necessarily, homeowners have to be able to participate because votes are being held, there's discussion that's happening. Um, the difference, though, between annual meetings and board meetings is that in board meetings, while they have to be open, while homeowners have to be able to attend, they do not have a right, homeowners do not have a right to speak or participate in board meetings. They can attend, but unless the board wants to have a homeowner forum or a discussion period, they do not have a right to participate. Now, there's a really notable exception to all of this open meeting, uh, all of these open meeting rules for both of these meeting types, which is that if the board is going to be talking about one of three things, so impending litigation in the association, criminal activity in the association, or personnel issues. So, not personal issues, personnel issues like hiring. The board can close those meetings to talk about those topics specifically. And that's just to maintain the privacy of whomever they're speaking about.
Well, so one question that comes up a lot, Ryan, regarding the that open meeting rule. What if the board wants to get together just to discuss like budget issues that are in preparation for maybe a budget discussion with homeowners? So it's sort of a preparation meeting. Does that need to be open as well?
Typically, no. The way that we like to talk about it is there's no rule against neighbors getting together and speaking about association business. But the distinction here is that no official action, unless there is some way that home or that the board can vote outside of an official meeting in your governing documents, no official action can be taken outside of of the board meetings themselves. So if the board wants to talk about how it's going to handle a particular thing or how it wants to present information at the next board meeting, that's perfectly fine. Homeowners don't have to be present for that. But as soon as official board action is being taken, that's a board meeting and that needs to be open to the homeowners.
Right, that's an important distinction. So that brings us to the issue of the governing documents. This is a common question from network members, and I think that most people are volunteers and they've had a variety of careers. Some are retired, some are semi-retired, some people are still working, but chances are they're not an attorney like you. So you're dealing with a document that is a legal document, and I think from an interpretation standpoint, sometimes that can be difficult. How can homeowners and board members alike ensure that they are complying with governing documents? Do you have any tips on how that really can be done appropriately?
Yes, at the risk of sounding trite, by reading them first and foremost. So I know that some of these documents can be really dense, can be very obtuse, but it is incumbent on all members of the association, the board, and homeowners to know what is in these legal documents. These are contracts. When you join an association by purchasing property within that association, you are agreeing to the contents of that contract. So just like you would carefully read over all of the contents of any other contract you're signing, you are going to want to do that here. In addition, and this is a practical advice, make sure as a homeowner that you are updating your contact information with the association. If, for whatever reason, the association decides to modify its rules and regulations, for instance, or modify its bylaws, or vote on a declaration amendment, if you have the wrong mailing address on file with the association, you're not going to receive those updates, and you're not going to know, you're not going to be in the know about what the newest version of those documents say. So make sure that you are updating your governing documents. And then for board members, because these are, in many respects, very complicated legal documents, if you have a question about whether or not something is required or what something means, talk to an attorney. That is what we are here for. We are here to help interpret the law, interpret these contracts, and tell you precisely what your duties, responsibilities, and obligations are within any given context. So that's how we can best help you.
Good advice, Ryan. One last question. So at HOA Day, you talked about and emphasized the importance of consulting with professionals and the business judgment rule. So can you provide some examples of when it's crucial for an association to seek expert advice? It isn't always needed, but it's probably more often than not.
That's a very good point. So nobody is an expert in everything. Nobody can be an expert in maintenance and in construction and in interpreting legal documents. So when there is ambiguity or when there is a question about, does this mean this or that, or do we need to maintain this or no, that is when it is best to consult a professional. So just like you would consult a professional for maintaining the decks, you would hire a contractor. Like I said in the previous question, this is when you might want to get an attorney involved who can say, hey, this is our legal opinion on what you have to do. This is important from a practical standpoint so that you know, as the board, what the best decision is to make. But it's also important from a legal perspective. You mentioned something called the business judgment rule.
Mm-hmm.
In Minnesota, the business judgment rule states that if you make a legal decision, so if you're following the procedures laid out in your documents, that you as the board believe to be in the best interest of the association, you as the board in your personal capacities, and quite often the association itself, will be indemnified or protected from liability, even if that decision may not have been perfectly in line with the law or perfectly in line with what actually was in the best interest. One way that you can guarantee that your decisions are in the best interest of the association is by getting a legal opinion about it. Most law firms like mine, Smith, Jaden, and Johnson, can pretty quickly turn around a legal opinion saying, you know what, in our advice is to do this, and boards can rely on that. There is case law in Minnesota where an association, following the advice of their legal counsel, made the wrong decision, but the courts protected them because they were following the professional's advice, even if it wasn't the best advice in that situation. So that's why consulting professionals, if you are a board, is incredibly, incredibly important.
Right. And as board leaders, we're managing a lot of money. We want to make sure we're using that money effectively and optimizing it, and using professionals and getting expert advice is always rule number one. So Ryan, it's been a pleasure having you with us today. Ryan Fargo from SJJ Law.
Thank you so much.
Thank you, Ryan. And if you are not a member of our network, it is free. Please join us at www.hoalnet.com and join the family. I'm Mark Foster on HOA Today. This is the HOA Leadership Network.